Hello and welcome to another episode of TaxSnax with me, Harriet Brown and Rebecca Sheldon, both barristers from Old Square Tax Chambers. And today, Rebecca, we are talking about tax penalties and human rights.
Yes.
Do taxpayers have human rights?
An excellent question that I hope you are going to get to, not me, in a few minutes. So, I'm going to start by setting out broadly how penalties interact with tax. So starting with a broad summary of penalties in a tax context, these can be divided into two general categories. So there's fixed penalties on the one hand, and there are tax-geared penalties on the other.
And what do these penalties relate to? What are we sort of looking at here? What am I getting a fixed penalty for, and what am I getting a tax-geared penalty for?
Right, okay, so the former category, so the fixed category, this generally concerns a failure by a taxpayer to act in accordance with a basic compliance obligation. So this would include, for example, a failure to pay tax or file a return on time.
And so that's sort of like your £100 fine for not putting in your self-assessment return. It's that type of thing. Yeah.
Yes, exactly. Whereas the latter category, so the tax-geared penalty, these penalties which arise in the context of taxpayer behaviour. So a tax-geared penalty arises where there is a failure to pay tax, and they are then calculated by reference to that tax. So this is usually expressed by a percentage of PLR, which is potential lost revenue. And there's a really complex definition of that, which we did on the last TaxSnax. So please go ahead.
We did a bit on the last TaxSnax.
Yeah, a little bit. So please go ahead and have a look at that before you come back to this if you're really interested in what PLR is.
Frankly, we could write a book on what PLR is, leave alone do a whole TaxSnax episode on it. So we're just not going to bother going into it.
I think it's important we just crack on. But I mean, sort of as a brief summary, it can encompass both tax that HMRC say has not been paid, as well as tax that has been deferred. Now, when we're looking at behaviour, what am I talking about? So firstly, this can include careless behaviour. So this is where a taxpayer fails to take reasonable care. And that may seem very circular, so I'll give an example. So a failure to take reasonable care might be checking the information included on a tax return. Well, if you don't do that properly, then that's going to be careless. And then you've got deliberate behaviour, so the more serious category. And this is where a taxpayer intentionally does something wrong. And for example, this might include putting incorrect information on purpose in your tax return. Now, there's also, beyond that, an even more serious category, you'll be delighted to know, which refers to deliberate and concealed behaviour. And this is where the taxpayer not only intentionally does something wrong, but also does something to cover it up. It's not very sensible. So, for example...
We're back to the £20 notes under the mattress here.
Yes, exactly. The £20 notes under the mattress is the best example of this. Another one might be if you omit to put your information in a tax return, so deliberate behaviour, so if you did that on purpose, and then you destroy the document that backs up what the information, the information that should have been included. So that would be both a deliberate and concealed penalty. Now, reductions in penalties can be available if a taxpayer discloses information, and these reductions can alter depending on whether a matter is onshore or offshore, and whether the disclosure was prompted or unprompted. And what do I mean by prompted or unprompted? I mean, if you discover that you've done something wrong and then you go to HMRC before they have a chance to come to you, then you're likely to get more off your penalty than if you wait for HMRC to notice. Now, when we are looking at penalties in terms of amounts, so the fixed penalties, they tend to be small. I mean, it depends how long you leave them for, and they can mount up. So in the case of penalties where there is a fixed penalty per day.
I think even with fixed penalties, there's sort of this distinction, isn't there? You get sort of, say, take the self-assessment return, you get your first £100 penalty just for putting it in on the 1st of February instead of 31st of January. If you leave it long enough, I seem to recall another daily penalty, which is still of only sort of like 2 or 3 figure amounts, will start to accrue. But say you don't do it for a year and those penalties are accruing for a year, that can obviously get quite chunky.
Yes, No,
but
absolutely.
yes, they are generally less.
Generally less. I mean, again, yeah, as Harriet rightly points out, if you leave it for a very long time, then it could be quite problematic. But generally speaking, they are smaller than the tax geared penalties, which can be huge. So, for example, the starting position for a failure to correct penalty, and just to give some background on that, this was where you didn't declare relevant offshore tax non-compliance to HMRC pre the 30th September 2018. The starting point there is 200% of the PLR. And I know we haven't really gone into what PLR is, but basically, suppose a taxpayer is subject to tax of 100,000. A 200% penalty of that would obviously be 200,000, as well as any interest on the 100,000. So that's 300,000 plus interest, which likely runs for many years at this point. So you can see there that tax geared penalties can be very serious indeed.
I mean, in that FTC example you've given, we're essentially talking about paying twice as much tax in penalty as the tax you're ultimately going to end up paying.
Yeah.
Yeah.
Which is obviously a massive, massive issue, and sort of where human rights comes in, I think, Harriet.
Yes, potentially, where taxpayers may have human rights. So, yes. Of course, much of the ECHR isn't going to apply in a tax context. And in particular, the very serious articles, so articles 2 to 5, are unlikely to be relevant. Those are things like right to life, not being tortured, things like that. Fortunately, in this day and age, no Sheriff of Nottingham, we're safe on those ones, so we're not going to talk about those. What you might find more surprising, if you're sort of new to this topic, is that in many circumstances, Article 6, which is the right to a fair trial, won't apply.
What is that, Harriet?
Right to a fair
apply. Yeah.
So, right to a fair trial is essentially you have a right to a fair trial, and that encompasses things like a fair and public hearing within a reasonable time. You have a right to be informed promptly of the charge against you. You have a right to silence. You have a right to legal advice, and importantly, you're innocent until proven guilty. And so, you may say, well, does it really matter because you have sort of a common law right to a fair trial? I feel much more comfortable we've got an Article 6 right to a fair trial, because the common law right's a bit... I've tried it in a few cases. We've got a common law right to a fair trial, and this isn't fair. Unsurprisingly, I've not got very far with that. So I think... So really, the question is, for Article 6, when does it apply to tax? Because as I've said, it doesn't apply in a lot of circumstances. And this is because tax, there's a very famous and much maligned judgment called Ferrazini in Italy of the ECHR. And this decided that tax does not come with Article 6 because it is an administrative matter. And Article 6 applies only to your civil and criminal rights. So it applies to civil and criminal matters, but not to administrative matters. Now, as I say,
right.
If you go and dig around, so Ferrazini is quite an old case now, it's from 2001, but if you go and dig around in the literature from that time, you can find an awful lot of criticism. And I think in a lot of cases, rightful criticism of it, including from Philip Baker KC, essentially on the grounds that the meaning of civil has been misunderstood here. Because it has a slightly different meaning in civil and common law jurisdictions. But anyway, that's the law as it stands. The ECHR have said that. I don't know how we'd ever get it turned the other way up. So if tax is an administrative matter, when can it apply? Well, it can apply in tax in a criminal context. And it's very important here to know that criminal has an independent meaning in European human rights law. And so essentially a civil penalty, if it meets certain criteria, can be a criminal penalty and therefore can be within Article 6. And so you get all those rights that we mentioned earlier. So this is a test that's been established over a number of decades as to whether or not a tax penalty or any sort of penalty from the government is going to be a criminal penalty. And it's summarised in English law in the Court of Appeal decision in Han and others against the Commissioner of Customs and Excise. And the test there is threefold. So the first criterion is the categorization of the allegation in domestic law, but that's just the starting point. So you might have a penalty that's a civil penalty. It's going to be determined in the tribunals. If there's a Barney about it, it might even refer to itself as a civil penalty, but that's just the starting point. So labelling is not determinative and is not decisive of the nature of the allegation. If the allegation in question isn't criminalised by the national law, you then go on to look at whether it is criminal in character for the purposes of Article 6. And you have two more criteria, which are sort of cumulative. So you're taking a global approach. You're not just saying, it's not a tick box exercise. As with anything important, they don't give us a clear way to deal with it. So the second criterion is the court has to consider whether or not the offence is one which applies generally to the public at large or is restricted to a specific group. If it applies to everybody, then despite its decriminalisation by the national law, it's probably going to be criminal for human rights purposes. So to pause there for a minute, what we're saying there is if a penalty applies to the whole body of taxpayers, it may well be a criminal penalty. Because the sort of penalties where we're saying it's not referred to as criminal in national law, it might be but it doesn't apply to everybody. That might be a penalty, say for example, applied by a professional body or applied to a sector of professionals, possibly. That's one example. So you might be able to say, and I don't know, I haven't looked into this, but you might be able to say that the penalties for tax advisors that came in a few years ago, that those wouldn't be criminal because they don't apply to a sufficiently large sector of the population. But that's before we've looked at the third criterion. And we're going to look at the third criterion, but after I say, in relation to the second criterion, if the penalty is punitive and deterrent in nature, it's probably criminal. That is sort of where we are.
What does punitive and deterrent in nature mean?
So essentially, the way that's been interpreted is twofold. So deterrent, if it's got a deterrent sort of nature to it, something like the publishing of tax avoiders or tax evaders details, that's very much deterrent. It's sort of pour encourager les autres. So anything that other people are intended to see, or indeed the taxpayer himself is supposed to say, oh, that hurt, I won't do that again. That's deterrent.
Right. And
so a very large penalty might be deterrent in nature. Punitive, a very large penalty is pretty much always going to be punitive. So I would say that a 200% penalty is prima facie punitive. It's not looking to redress an imbalance. It's simply a punishment. It's not sort of saying, well, interest wouldn't be punitive, but and a small penalty, which is sort of a slap on the wrist, may not be punitive. There probably is, but sort of a chunky penalty. I mean, it wouldn't need to exceed the tax charged, in my view, to be punitive. That sort of penalty, I think, should always be regarded as punitive.
Yeah.
And so
sorry, I completely waylaid you there. Please
no,
continue.
don't worry. That was sort of what was said in Bedanoon's case and Georgiou's case, where it was essentially said that a substantial financial penalty which is imposed by way of punishment and deterrence will suffice. So this has been looked at in the context of tax in tax penalties from a number of jurisdictions. And so if you've got a big tax penalty, which is intended to be punishment and intended to be deterrent, you're probably within the definition of criminal.
Yeah.
And so what I say there is, on many occasions, tax geared penalties are going to come within the ECHR meaning of criminal. And as such, you should get your Article 6 rights applied. And possibly in the context of HMRC, one of the most pertinent of those is this fair and public hearing in a reasonable time and right to be informed promptly of the charge. So, and again, just to stop there, just because Article 6 comes in relation to the penalty, you don't have Article 6 in relation to the tax. You're still only going to get it in relation to the penalty, even if they're heard together.
Right.
So it doesn't give you a blanket protection, sadly, once you're in for the penalty. And so with those, there was a case back in 2004 called King. There, the ECHR held that the charge, in inverted commas, arose when HMRC warned the taxpayer of potential criminal liability, and that would of course include ECHR criminal liability. And what happened in King was that there was they were going to pursue a criminal prosecution, which they didn't, and then issued a civil penalty instead. And the date of the charge there was held to be the date on which HMRC warned the taxpayer of the criminal liability rather than the penalty. So that's been interpreted quite widely in a tax context in the case of King, because what essentially they said was, look, they told you about this when they told you they might be coming after you in criminal proceedings. So that's sort of where we are. Rather than when they said they were going to do that penalty, when they said they were going to apply the penalty. And so that's one thing to be aware of. But we've all seen cases, I think, where the hearing is ultimately so long after the events in question happened that this right to a fair and public hearing in a reasonable time, one must wonder whether or not that has been infringed in a way that means that a fair trial is not possible, in effect. A couple of other points, well, one more point on Article 6. Your right to silence is not absolute. Adverse inferences can be drawn from a taxpayer's silence, and for an example of that, you might want to see the case of Umar Butt, which was an MTIC fraud case a few years ago. So Article 6 might apply to penalties. We do have other articles that might apply. We're going to go through those fairly quickly. First of all, we've got Article 7, and that protects against punishment without law. And this means that no one shall be held guilty of any criminal offence on account of an act or omission which did not constitute a criminal offence under national or international law at the time when it was committed, nor shall a heavier penalty be imposed than the one that was applicable at the time the criminal offence was committed. So Article 7 might be irrelevant where a penalty is retrospective or has retrospective effect. And again, this is only going to apply where the ECHR penalty is, where the penalty is ECHR criminal. So this is just applicable to criminal matters, not to civil matters, but it has the same effect for our purposes. So there's that. And Article 7 tends to be quite fact specific, but it's definitely worth remembering, particularly where the law has changed, and you need to look at the effect of that law changing on your specific circumstances. Has there been anything with retrospective effect? If there has, you may want to look at whether or not Article 7 applies to that. Article 8 addresses a right to private life, and this is potentially pertinent in the context of requests or mandates for information. So we have a lot of international regimes now, and the automatic ones are unlikely to infringe Article 8. Tier requests may infringe Article 8. It's going to depend on the content and context of it. But again, it's worth knowing that Article 8 is there. It's not going to apply in a lot of cases because Article 8 is one of these articles where there is a sort of derogation, there's a carve out for anything that is in accordance with the law and is necessary in a democratic society in the interests of national security, public safety, or the economic well-being of the country. So obviously, obtaining tax information may well be within the interests of the economic well-being of the country as a whole. Yeah. So it would have to be a quite egregious sort of impact that it has on the on that person's right to a private life. But
what sort of interference? I'm just thinking out loud. You may not have an example, but what sort of interference would justify saying that right was infringed?
I'm not aware of any case law, for example, where it has been said that it's an infringement. But I think, for example, where you might say it was an infringement is where information that isn't relevant is sought. Right. So take the example of a tier request where the National Tax Authority is inquiring into Mr. X, and they write to Mr. Y. And they ask the authority in, so jurisdiction 1 is inquiring into Mr. X. Jurisdiction 2 has tax records for Mr. Y. Jurisdiction 1 writes to Jurisdiction 2 and says, we are investigating Mr. X. Please, can you get this information from Mr. Y? And that second authority writes to Mr. Y and says, Mr. Y, we're investigating you. Please, can we have the following information? Now, there's all sorts of problems with that from a regulatory perspective anyway.
Yeah.
However, none of this information is relevant to determining Mr. Y's tax position. And so that might well infringe his Article 8 right to private life, because it's not necessary. It has to come within this exception, i.e. be necessary for the general interests of the economic well-being of the country or whatever it is.
Yeah.
Clearly it isn't, because it's not going to tell them anything about his tax position.
No.
So that's one example. I mean, if they just put Jurisdiction 1 is investigating Mr. X and we'd like this information from you, they'd probably have him bang to rights. But that's just that's one possible example that I can come up with off the top of my head. So that's Article 8. We then get Article 14, and that prevents discrimination. It provides the enjoyment of the rights and freedoms in the Convention shall be secured without discrimination on any grounds such as sex, race, colour, language, religion, political or other opinion, national or social origin, association with a national minority, property, birth or other status. It generally would tend in a tax context to come up in the context of indirect discrimination. But again, it's one to just keep your eye on, because if you get specific facts, you might see that that is the case. And now finally we come to the other biggie, which is Article 1, Protocol 1. And this provides every natural or legal person is entitled to the peaceful enjoyment of his possessions. No one shall be deprived of his possessions except in the public interest and subject to the conditions provided for by law and by the general principles of international law. So the government can't just take stuff off you willy-nilly. It has to be in the public interest and subject to the conditions provided for by law. So tax quite clearly comes within that. Yep. What A1P1 then goes on to say is the preceding provision shall not, however, in any way impair the right of a state to enforce such laws as it deems necessary to control the use of property in accordance with the general interest, or to secure the payment of taxes or other contributions or penalties. So you might say, well, why do we care about A1P1? Because they're allowed to charge us tax and penalties and anything else they want to.
I was about to ask you that very question, Harriet.
Right. Yes. It's
why do we care? Why do we care about A1P1?
We care about A1P1 because any measure that they take under that second sort of exception has to be proportionate. We all love proportionate, don't we?
We do.
So we're then into proportionate, and this was discussed by the upper tribunal in a case called Edwards and RCC at length. It summarises a lot of previous higher authority. So we've got some House of Lords, some Supreme Court, some Court of Appeal in there. And in summary, what it said is this: to assess proportionality, and this was in the context of a scheme which imposed penalties on lorry drivers who intentionally or negligently allowed clandestine immigrant entry into the UK, so the test for assessing proportionality, the scheme, it's not that it's merely harsh, it's that it's plainly unfair, so that however effectively that unfairness may assist in achieving the social goal, it simply cannot be permitted. So it's quite a high bar to say that it's not a proportionate measure.
Right.
And there's also a wide discretion for the legislature in devising a suitable scheme, and there should be a high degree of deference by the court to Parliament in determining the legality of a provision. So essentially the court, it's almost like a Wednesbury unreasonable test, i.e. is it such an unreasonable imposition that no reasonable government could apply it? That's not the test, but it's not completely dissimilar to that in terms of how high
in terms of the level. Yeah.
Yes, exactly. Yeah.
Okay.
So in Crown on the application of Daly, Lord Steyn set out the three-stage test from De Freitas, and he said when you're looking to see whether or not something is arbitrary or excessive, you look at the legislative objective and say, is that sufficiently important to justify limiting a fundamental right? You then look at the measures designed to meet the legislative objective, and are they rationally connected to it? And then you look at the means used to impair the right or freedom, and are they no more than is necessary to accomplish the objective? Now, these are obviously difficult questions to answer, but those are the questions that we need to answer when we're looking at whether or not something is proportionate. And again, that seems like quite a high bar. That was maybe tempered a little bit by some later comments in the Daly case, where it was said it's implicit in the concept of proportionality that not merely must the impairment of the individual's rights be no more than necessary for the attainment of the public policy objective sought, but also that it must not be an excessive burden on the individual concerned. And this was sort of drawn out in a case a few years back called Total Technology, where they looked at two things. And the first is the scheme, so that it might be a legislative scheme. In that case, it was a VAT penalty for late filing, tax geared VAT penalty for late filing. Is the scheme itself excessive? And if you look at that and say, yes, that's game over, it infringes A1P1. If you say no, you then have to go on to the second stage, but you look at whether or not on the facts of that particular case, it's excessive for that individual. And if the answer is yes there, the scheme itself doesn't need to be excessive if in all circumstances, if in the circumstances in point, it gives rise to an excessive burden.
Right.
That makes sense. So it's a two-stage test because, of course, the scheme itself could just be so OTT that it's manifestly excessive and arbitrary.
Is it more common that you'd be successful on that latter one?
Yes.
Yes. It's just that, yeah.
To be fair, governments don't generally set out to be arbitrary and unreasonable.
Well,
I mean, they might achieve it, but they don't set out to do it. So it is much more common to go, oh, this is a funny set of circumstances.
Right.
What do we do here? So the Total Technology case was sort of, it was in a line of cases where there were large penalties, but the lateness was quite minor. So I think Total Technology might have been 1 day.
Okay, I see.
So yes, so you can see how that might have arisen there.
Yeah.
And is it reasonable to charge somebody a massive penalty because they're a day late?
Probably not. Is my feeling.
Yeah, the courts may not have agreed with you, Rebecca, I'm afraid to say.
Still, would have given it a go.
Yeah, so they then go on to say that not only must the measure depriving a person of his property pursue on the facts as well as in principle a legitimate aim in the public interest, but there must also be a reasonable relationship of proportionality between the means employed and the aims sought to be realised. And so another way of putting this is a way that the ECHR put it in a case called Sporrong v Sweden. And they talked about a fair balance being struck between the general interest of the community and the protection of the individual's fundamental rights. And you can't get that balance right if you put an individual and excessive burden on a person. So that's sort of, I think mostly goes towards that second element of the test. Is it in the facts of the case, has it caused a problem?
Yeah.
So there's that. There are plenty of examples in case law of A1P1 being applied, and even more of it being argued and not applied, but there's plenty out there on it. So have a look. All I think we're really saying is, particularly where you have tax geared penalties, bear in mind that the European Convention on Human Rights may be in point.
Yep.
This is particularly important where we have the ongoing demise of EU law rights-based defences. There are still some things that come within that, but we're getting further and further away. And so in that context, it's increasingly important to look at what other rights-based protections there are for taxpayers, and that primary one is the ECHR. So that is, I think, unless you've got anything to add, Rebecca, our introduction to penalties and human rights. And we hope it's been helpful. And that you have, I won't say enjoyed it, but managed to listen to it all.
Thank you. Bye.
Bye.